I'm Barry Bowman. Welcome to a bonus episode of the docuseries Beware Mysterious Mark, a harrowing true account of elder financial abuse. Today's episode features producer Bill Collins in conversation with lawyer Charlotte Salomon, King's Counsel and specialist in wills and estates. Charlotte is a member of the Estate Planning Council of Victoria.
My name is Charlotte Salomon, and I'm a lawyer with Infinity Law. I practice in the area of wills, estates, and real estate as well.
And so you're here as well as part of the Victoria Council on Estate Planning?
It's the Victoria Estates Planning Council. Yes, I'm on the board of that. And that's a group of professionals, mostly made up of lawyers, accountants, and investment planners who all deal with wills and estates. Okay, but just as a proviso, this is not meant to be legal advice.
Fair enough.
So I'm a lawyer, and even though I am speaking to you in a capacity of a lawyer, but also as someone who's on the board of the Estates Planning Council, what I'm saying today can't be construed as legal advice, because every lawyer would need to sit down with their client and hear an exact fact pattern of what's going on and the different modalities involved before they could give legal advice on a matter.
In general, can you give our listeners a sense of what people are trying to accomplish with estate planning and how it might impact their life plans?
Well, estate planning is important for many reasons. First of all, so there won't be any surprises. So everyone knows, and the person who's doing the estate plan knows what is going to happen after they pass away, and also what's going to happen if they lose capacity, because there will be a point in time where most of us will lose either physical or mental capacity, and we won't be able to make our own decisions. Something from banking and dealing with financial institutions and paying our bills to decisions as to where we're going to live as far as a old age home or a care facility, and what medical interventions are going to be made to prolong our lives.
How often is it that the individuals define when their capacity slips, or somebody else defines them as, say, not able to manage their affairs, their financial affairs particularly?
Yeah, that's a difficult question. And the advice I would give to my clients is that you need to have everyone on the same page. So if someone is coming to my office to prepare estate planning documents, one of the important documents is a power of attorney. And the power of attorney is the document that dictates what is to be done for your financial needs if you cannot take care of your financial needs yourself. And in a power of attorney document, we usually have them as enduring, which means that they are valid the moment that they are signed, as opposed to a springing power of attorney, which is only valid upon a certain event occurring, like a medical event. We usually do enduring power of attorneys to make sure that we have everything covered. What if a client is going on a trip somewhere, and let's say 4 months, and they're going to be away and someone has to pay their bills? Or what if they subsequently become incapacitated? So that's why someone would do a power of attorney and name people as their attorneys. And then the big question is, what happens to this document? I just told you that it's enduring, so it's valid the moment that it's signed. What happens to it? Do I just give it to the person that's did the power of attorney, or give it to the attorneys? No. What I usually do with it is I put it in my safe. At the law firm, we have a fire safe that stores all these important documents. And then I get the person who signs a power of attorney to basically sign a letter as to when this is to be released. So there's certain conditions that are on that letter. First of all, if they tell me to release it, saying, Charlotte, I'm going to Japan for 4 months, I won't be around, please release my power of attorney. Or in the case of a doctor telling me to release it, and this has happened before, where I get a call saying, yes, your client, Mr. So-and-so, well, you may not know this, and that client may appear normal to you, but that client suffers from frontal lobe dysfunction, and therefore that client is giving all their money away to overseas callers. So the power of attorney needs to be invoked to remove that client from their capacity to make their financial decisions, because they don't have capacity to do so. So that's another scenario. And then the third is if I know it should be released. Like for example, I usually have a good enough relationship with my clients. I keep in touch with them. I know when they're getting frail. I know when they're in the hospital. And it seems to me that this is the time that it should be released. So, and then I have absolute discretion. The clients do give me that to release the power of attorney if something happens, that they get hit by a bus or whatever. So it is kept in my safe until those conditions are met. And that's a bit controversial too, because obviously without a power of attorney, the person named as attorney cannot go to the bank and do the banking. So once a power of attorney is signed, just because it's signed doesn't mean that person has the authority. That person who's named as attorney has to receive the power of attorney signed, take it to the bank, and the bank will file it and know that this is the attorney that they are supposed to be dealing with instead of the person that made the power of attorney. So it's a bit complicated in that. And, a fact scenario that can happen is that the bank has one power of attorney that a lawyer prepared, and then a person is taken by perhaps another family member to a different lawyer to prepare a second power of attorney that revokes the first power of attorney, and the bank isn't notified as to that. So it's an interesting dynamic here because we think the power of attorney is going to be the final document, but someone has a right to revoke their power of attorney as long as they have capacity to do so. And if someone is taken to a lawyer who's not familiar with them, and possibly by a friend or family member who does not have the best intentions in mind, they could throw one over on the lawyer who's not aware of the situation, the new lawyer, and that new lawyer could prepare a document that contradicts what the original instructions were given to the original lawyer.
So presumably a lawyer has a duty to do some investigation prior to transferring the power of attorney.
It's not so much a transfer. It's a brand new one. And every time, usually, when a lawyer does a brand new power of attorney for someone, the first line is, I revoke all previous powers of attorney. The only time we don't do that is if we're doing a power of attorney for, let's say, British Columbia, and our client has assets in another jurisdiction. We will say, this is for the BC assets and does not revoke the, say, Ontario power of attorney. But usually it does revoke it. And the lawyer holding the original power of attorney, who may not have released it yet, doesn't even know that their original power of attorney that they drafted for their client has been revoked.
And there's no requirement for the new attorney to inform the old one, presumably.
No, there isn't. And that's why banks are very wary of dealing with powers of attorney. And banks are now asking clients to identify what's called a trusted contact person. So this is over and beyond the person named as a power of attorney. And this is someone that the bank wants to have on record to say, okay, this is who, let's say, Mr. Smith trusted all the times that he's been with us as a client of the bank. And if we get a power of attorney naming someone else, we know to ask this trusted contact person what's going on.
So the bank also accepts some level of due diligence when they're dealing with clients that might have had for many years and really might not know that there's been a shift in their conditions.
Exactly. So that's why the banks are trying to implement the trusted contact person with their clients. And you're going to see that more and more. It hasn't been done very often until now, but going forward, most banks are going to request that information.
Yeah, safeguard, basically.
Yes.
How much, I presume the banks deal with this every day, but I was wondering how much the liability is held in the bank for, saying, allowing a joint account which contravenes what, say, the family member might know of as existing in their original power of attorney.
Yeah, there may be some liability on the bank if they know that there is a trusted contact person, yet the person who is their client comes to the bank with someone else and puts that person's name on a joint account.
Right.
But luckily, the Supreme Court of Canada has put on some safeguards to that. So especially in British Columbia, we follow a case called PACOR. And the PACOR case says that if there's joint account holders, the survivor of that joint account which is probably, the younger person, let's say, that person holds a duty to the estate of the original bank account holder to hold what is in that account for the benefit of that estate. So there's not an automatic in estate law that it is known that this money is transferred specifically to the other account holder by virtue of survivorship. There is some sort of need for that person to prove why they should take as a survivor.
Right. One of the things that we often talk about in terms of the story of financial elder abuse is related to confidentiality. We often say confidentiality is not your friend. So can you talk a little bit about, in terms of, I'm an estate planning professional, I'm dealing with my client, what's the duty of care with respect to confidentiality if you suspect something may not be right?
Okay, so as a financial planner, you do have a duty of confidentiality unless you've had your client sign that document identifying a trusted contact person. So we go back to that. As a lawyer, it's interesting because you do have a duty of confidentiality, but that's why when a client is in a lawyer's office, it is best for the lawyer to talk to the client about who should receive copies of the documents being signed that day. So what I would suggest to some of my clients is that, you name your child as executor of this will, perhaps share the will with them, or perhaps if you've named your child as a power of attorney, perhaps share the power of attorney with them and also with other people as well. So there should be open conversations among families, and that would really cut down on the problems later. So if a parent names only one child as a power of attorney and the other child as an alternate, I would suggest to that parent that they send copies of the power of attorney to both their children and explain why they set it out like this, or have a discussion ahead of time before signing the power of attorney as to why child number 1 is first and child number 2 is second. And that doesn't just apply to a power of attorney. As I mentioned, that would apply to being executor of a will, trustee of a trust, and even representatives of representation agreements. And we haven't talked about representation agreements, and those are important as well. So that is what we would call a power of attorney as to medical decisions. It's called that in Ontario.
Right.
In BC, it's called representation agreements. Other people may call them living wills. So that's an agreement that you also name a representative, similar to power of attorney, but this representative is usually only dealing with your medical decisions. And it's important that family members are aware of who is first on the list for the hospital to call, who is second, what are the wishes of the person who named the representatives, and what they expect the representatives to do in their place about their medical decisions.
And presumably a power of attorney is not necessarily the same person as a representative?
No, and that's an interesting point, because one thing we find with powers of attorney is it's really detrimental to name someone outside of British Columbia to deal with British Columbia assets. Right? And same with a will. If you name, let's say, an American person as your executor of your BC will, it becomes an American estate. There's really a lot of problems with that. There would be American estate law that applies and could apply to that estate, along with different taxes that you would not expect your estate to have to pay.
And just because you name an executor as someone that's not from BC or Canada even.
Not from Canada, right? I mean, even if you name an executor from England, I mean, there will be problems. But the good thing about the representation agreement, because if you're talking about one just dealing with medical decisions, you can name someone outside of British Columbia, outside of Canada, if that is the person closest to you who is best to make medical decisions in your stead.
Right. So it does bring up the challenge when you're dealing with a representative agreement and a power of attorney, because if you're deemed capable of making a decision, you can revoke the power of attorney. A representative can access, perhaps, I presume, if you let them, your medical records.
Yes, a representative could access the medical records if you let them, and the representative has other duties as well. For example, what's coming up these days is being put into a care home. A representative can make the decision of which care home someone is to reside in. And that's interesting because that has some overlays with the power of attorney, because someone has to pay for this care home. So the representative and the person named as a power of attorney should be on side with each other. Because obviously if the representative puts someone in a home that is too expensive, and the assets won't last, that's going to be a difficult situation. So the power of attorney who has access to the bank accounts needs to be in communications with the medical representative.
It sounds to me like your advice would be to safeguard the multiple aspects of aging, and as you get to the point where you may not be able to make all of the decisions, you may be able to make some but not all. It sounds to me like it's a good idea to have a representative that may be separate from the power of attorney. Is that reasonable?
I wouldn't think so. I think one and the same is a good idea. What some people will do is they'll say, well, this child of mine is better in financial decisions, and this child of mine is better in, healthcare decisions. And they switch. So the power of attorney will have child number one as the first attorney and child number two as the second, and the representation agreement will be the opposite. I don't see a big problem with that as long as I said, there is communication here. Well, this is a messy area of law, and I'll tell you why. The whole issue of capacity is messy. So having medical capacity does not necessarily mean that you have legal capacity, and vice versa. So to assess legal capacity as to whether someone is able to do a will or revoke a power of attorney or make a new power of attorney, that is a totally different test that a lawyer would do as opposed to what a medical professional would do. To have legal capacity is different than medical capacity, but the other thing that's a huge difference is that someone may be deemed to be medically incapable. But as we know, when people get older and have dementia or have Alzheimer's or other types of diseases like that, they're not totally incapable all the time. They do have these bright moments where they're able to understand what they're doing, understand what assets they have, and who they have to give it to. So I think you need people advocating for people who have these types of disabilities, mental disabilities, and people who have age-related dementia. They have to be advocated for. Just because they get the diagnosis does not mean that they should not be involved in any of their decision-making.
Do you get an experience where they may not see eye to eye in terms of the tactics that they use, but everybody has the person's best interest or their mother or father's best interest at heart?
So the interesting thing about best interest is something that needs to be discussed. When someone is capable of making their decisions, they do not need to have the approval of any of their possible beneficiaries to their estate to deal with their estate, right? So if someone in their lifetime with capacity wants to sell their assets and give them all to charity, that's their business. So it doesn't become an issue that the courts get involved with unless the person has passed away. And then in British Columbia, we have something called WESA, and that is a statute that requires the will maker to consider the duties they have to their beneficiaries. But while you're alive, you don't necessarily have that same duty. And then the issue of capacity comes in and someone being taken advantage of. So that's a different scenario too. So someone may have lacking capacity, yet perhaps a caregiver, perhaps a family member is taking advantage of that person and is liquidating the estate in order to defeat the beneficiaries that would have been entitled to the estate once the person passes away. That is the biggest gray area we have.
Right.
So for example, if you have a child of an elderly person saying, Dad, I need the money. Can you please, put $50,000 in my account, write a check for me for $50,000. And then the child takes it to the bank or there's an e-transfer, even better. No one has to go into a bank. And the father is e-transferring money to the child. That $50,000 is gone. So the beneficiaries ultimately will wonder, where is this $50,000? Then to go backwards in time and to say, okay, did my parent have capacity to do that transaction at the time they did? That's a very hard thing to prove and disprove.
So let's look at it from perhaps a slightly different angle. I see my elderly parent befriending somebody else, and I'm not 100% convinced that elderly parent or that I'll call him predator has the best interest at heart. So what do you suggest, probably from the perspective of the child, for planning for that possible eventuality, or when you actually see that eventuality coming to fruition? So can you sort of take us through that?
Sure. The question is there a power of attorney? And if there is a power of attorney, this may be the time to have it invoked. This may be the time to contact the lawyer, if you don't have a copy of it, the lawyer who drafted the power of attorney, expressing your concerns, and then perhaps expressing your concerns to the parent. What the lawyer could do in the circumstances that would make sense is to have the parent in and try to get some answers themselves. The lawyer could call the parent's doctor and also see if there's any concerns. So there is a lot of inquiry that can be done. There's also resources available for a child in that circumstance. So BC Seniors, which is a provincial organization, has information on protection from elder abuse. So that's one of the resources that the lawyer could point the child to. And there's also a new organization called the Canadian Centre for Decision-Making Capacity. That's a nonprofit, brand new, dedicated to advancing incapacity literacy. And that's something that's going to be moving forward because there seems to be such a huge hole in what's to be done in these situations.
What's the role, if any, of the public trustee?
So I'm glad you asked that because I just talked about, well, if there's a power of attorney, the lawyer could release it. If there is no power of attorney, then this is where we talk about committeeship. So the public guardian and trustee is a great resource that gets involved if there's no power of attorney and if someone's finances are at a risk of being depleted as a result of abuse or mishandling. And the BC Public Trustee can work with the family in making a court application for there to be a committee. A lawyer can also help the family in this as well. So a committee would stand in place of an attorney named in a power of attorney.
Okay.
The issue with the public guardian and trustee is this. While they have a wonderful service for people who don't have anyone to name as their power of attorney, you do name the public guardian trustee as a committee. The issue is the cost of that. So there is a cost for the public guardian and trustee to become involved and to safeguard the person's assets.
Presumably a scenario whereby a new friend comes along and the friend starts to inject themselves into an elderly person's life, and the child sees this happening, and this new friend, for example, deliberately tries to separate families from decision making. It seems to me there's not a lot that anybody can do if the individual, the parent, is deemed to be capable and have the capacity. There's not much that can be done. Is that a fair comment?
Well, I did talk about the two resources, right? So we have BC Seniors and also the new resource, the Canadian Centre for Decision-Making Capacity. But there's one that we didn't talk about, and that's the police.
Right.
So if you think that your parent, your elderly friend is being bamboozled, so to speak, there's nothing wrong with contacting the police and asking them to do a wellness check on the person, especially if you feel that you are being cut out from the life of that person that you care for. You're not allowed to see them. You're not able to talk to them on the phone. Or, let's say their doctor wants to see them, but the patient never calls to make a doctor's appointment, then I think that's a really good avenue to go, is through the police.
Right. Thanks for bringing that up, because criminality is another dimension to this. I can tell you exactly that in the scenario that we're going to bring forward, and which we may not and eventually comment on the specifics of the case, 5 practitioners in the sphere of influence, from a lawyer to daughter to a notary public, who first discovered the individual, the predator's attempt to sever the title on this fellow's property. 5 individuals phoned the RCMP. The RCMP did a wellness check twice. But as the person was deemed capable of making their own decisions and there was no fraud involved, the RCMP were powerless to do anything. Even though they said, we'll keep an eye on things, their comment was, do what you can to stay close as you can to your parent, but there's not a lot that we can do. Do you have a comment on that at all?
Unfortunately, that happens. And what can be done? I think then you would need to get the public guardian and trustee involved and make an application to court if there's no power of attorney. If there is power of attorney and someone is misusing that power of attorney that they were given by the individual, then a court application can be made to remove that particular person or declare that power of attorney invalid and have another attorney appointed instead, or a committee.
I understand that it is perfectly legal in many instances for somebody to push someone off title without them ever knowing. So, for example, a daughter is 50% owner of a house with a father, and the father decides that he's going to take his 50% and give it to somebody else. No, the daughter may never know that the title was severed. And that's something that I guess I want to make people aware of, that you should not much you can do from what we see. Maybe you can tell us something different, but also give us sense of advice on best approaches when you do see somebody that's intent on stealing somebody else's estate. Can you talk a little bit about those two things?
So the first thing you're asking about is title transfers. So if a title is held in the name of A and B, they both have to sign the form transferring part of that title.
Is that right?
If it's joint tenants, yeah, they do.
Okay. What about it's 50? Again, I have to go back to my research. There's another component.
Yeah, tenants in common and transferring that share. So if it says specifically on title that A owns 50%, they could theoretically transfer that 50% without B, who owns 50%, knowing, but I think any lawyer would be very reluctant to put that through.
Right. So legally it can happen, but morally it's probably there's level of care that needs to be undertaken.
There's always things that can happen that get through the system. And that's why powers of attorney are also filed at the land title office. So in the future, if someone tries to sell their property, the power of attorney is already there. So you can't do it under a different power of attorney.
Is that an instruction that you would have to give to your estate planner or your lawyer in that instance?
Usually, and that's quite often the case when someone is trying to sell a property, and let's say they're going away. This happens all the time when someone goes away and they have a sale pending of their condo or their home, and they're not going to be there for the closing date. They do a power of attorney naming someone, but that's just for that specific reason to do the real estate sale. And then we file that power of attorney. So you will see powers of attorney filed in the land title office for that reason.
Okay, so if I'm buying a house and I'm doing my records check, or my lawyer's doing the records check, that will be flagged.
Yes.
As something that would have to come up and be solved before you can transact.
Yes.
So if you were sitting down, what would you be advising?
My advice would be for everyone to be on the same page, and for the family to know who is named as the power of attorney, who is named as the executor of the will. I think everything has to be out in the open in order to best protect any elderly people in your life. And it's hard because in some families, there is family conflict. There's second marriages. Those are also difficult to handle. Third marriages, kids from each marriage. But in order to protect our family members, everything should be in the open.
Cool. Is there anything that you want to add other than what we've talked about in terms of this?
Some people may think that if someone's going to challenge my dad's decision, I'm going to videotape this and make sure that everyone knows it's fine. Some courts don't allow that type of evidence, the video evidence. It wouldn't be allowed. It's very fraught with disaster, video evidence, and there needs to be consent on all parts. I guess if I was to be, able to have a magic wand, I would like to see a more streamlined process for getting evidence of capacity. And maybe video would come into it. I'd like to see the law reform people perhaps look into this a bit further. But right now, whether someone has capacity is based on so many factors, and not everyone follows the same tests of capacity. So I think there is a place for videotaping, but videotaping is also just a moment in time. And it goes back to one of my earlier comments that just because someone has been deemed to have dementia or the beginning of Alzheimer's, it doesn't mean that they have no control over their affairs, because there are these moments of light. I mean, I had someone come to my office with some very strange ideas of, the fact that they were abducted by aliens once and everything. Does that person have capacity? Well, as long as they knew, what assets they had and who they had it to give it to and what their responsibilities were, yeah, they have capacity, even though they may have some very strange ideas in their head about the way the world works. So, yeah, I think videotaping is something that can be used as a tool, but don't expect it to be admissible in court.
Right. Do the courts, once the changes have been made, does a family have much recourse except to apply to the court? And how would they would engage a lawyer, presumably, and
yes.
What would be that process?
As I mentioned, that if someone has done a power of attorney unbeknownst to the original power of attorney, then they could go to a lawyer to get the attorney substituted or get the subsequent or the second power of attorney deemed invalid.
Right.
That can be done. The difficulty is when there are two different individuals vying to be attorney. And what is a judge to do? Well, then quite often that's where the public guardian and trustee has to come in as well.
Okay. Then the other comment around, say, capacity, the medical side, it is clear from our story that if the group of, say, geriatricians here or the hospital setting or the VHA setting on Vancouver Island may make a decision that says this person is not capable of making decisions on their own. We have the case in point where they went to and paid for another geriatrician's advice, which overrode the first level of advice, which allowed the piece of paper to say they're capable of making a decision to bring to the new lawyer to change the power of attorney. I guess there's not much that anybody can do to stop that.
Sounds like a great lawsuit.
Right.
There isn't much. I mean, geriatricians don't always agree. And as I said, people with dementias do have these moments of when they can pass, any mental tests with great ability and high scores. But, with that being said, their fridge is full of 80 oranges because they keep thinking they need oranges. So it's such a gray line.
Right.
And that's part of it. And you know what? Also, there's also a risk of, people giving away their money and falling victims to fraud. And I think that is just evidence that goes towards the diminishing capacity of the individual and why they may not want to handle their own affairs.
What's the chances of somebody, and this is my last question, when these things might have happened and then the person passes away, is that the place you're likely to challenge the results of the estate? And what's the likelihood that you're going to affect the result?
It's an interesting question. It's hard to say the likelihood of, success. But I'm going to give you one scenario. Let's say someone leaves money to an individual who's not necessarily a family member, but maybe someone who's prying, and people who would have inherited, such as their children, or their siblings or their parents, however the case may be, are entitled to notice of this will. So when the person passes away, before the will can be probated, the executor has to prove that they've notified the children, if there are any, or the parents, if there are any, or the siblings, if of the deceased, before the will can be accepted into probate. So then it's open that this will is giving this amount of money to this caregiver or this person that shouldn't be necessarily in the deceased life. So that is a safeguard that WESA does provide.
Right, through the probate process.
That's right. And also, other beneficiaries have their own checks and balances. For example, if the will maker is leaving money to a charity and that's part of a will, a lot of these charities don't just sit back and wait to receive the funds. They scrutinize what the executor is doing. So if the executor is not doing their job well, they're going to have to pass their accounts as an executor. And the same thing with a power of attorney. If we move back to that, a power of attorney, someone named as power of attorney, can always be asked to pass their accounts as well to make sure that no money is disappearing from the person's bank account by virtue of this power of attorney. So there are checks and balances throughout different stages. At the end of the day, though, is it enough? Well, it's hard to say. I think there's always fraudsters that are going around and preying on elderly people, but luckily we do have some community resources like BC Seniors, for example, that talks about elder abuse and scams, and a team approach. Have the lawyer on side, have the doctor on side, have the trusted contact person on side, and they should all know what's going on, and that is the best way to prevent seniors being taken advantage of.
You've been listening to an original broadcast of Radio Sydney, coming to you from the Mary Wynne Spears Centre in downtown Sydney by the Sea in beautiful British Columbia. Thanks for listening, and please join us again.